You can use it for the laptop. The presentation is loaded over there. Slides. Good morning, everyone. I am not able to do that. So, thank you for the introduction. Myself, Kunal Nasari. I'm for technical plus legal background. I'm a patent attorney. So, first of all, I would like to have a kind of a disclaimer that whatever I will going to present today, it is not a kind of legal advice for your any of the project. So it's a kind of educational purpose. So if you have an invention and if you are developing anything related to software related to anything, so it's a kind of a thing that you need to be cross-checked in a detail. So that's why we are here to provide what need to be cross-checked first. And then we should move on related to patent filing and how we can able to work with the commercialization of the patent or patent operating. So it's a kind of informative station. Whatever advice you give, they need to be dealt with the proper scrutiny. Then as an attorney, we will be able to guide you to any of the subject. So this is a kind of a basic, we can say, disclaimer that we will going to provide you detailed advice, considering what is the depth of the technical aspects that you are present to us. So related to subject matter, first I just want to know that what is your thinking related to IPR innovations and we can say uh, as a BBA student, as a MBA student, as a faculty, what you are thinking related to innovation, patent, IPR? So, like, I just know a brief from your end. What do you think related to IPR? So we can have a kind of an interaction session. I can guide you in the that sense that no one thing related to I think that how I can able to go into detailed explanation related to IP. So as a technical person, as a doctor, what do you think? What is the IPR at the current state of the mind? Can you answer that? As an IPR, what do you think? Intellectual property right is a subject matter has a kind of impression that would be here. Right?
Understanding is concerned, we feel that our own idea about a different product or some technique, random related technique, which is our own topic. Maybe that is
And related to innovation, what do you think as an innovation? What's considered there? There's a difference between invention and innovation. So I just want to set a brief, we can say the context that what we need to discuss. Do you know what is innovation? There is invention, there is innovation. You might have observed the Philips commercial that innovation in you. That tagline is Philips innovation in you. So you can consider as an innovation. Right. Okay. Any something different. Yes. Perfect. So see, there are two things that innovation, invention, and innovation. So if we are distinguish the both of the things, and invention is considered as a product of lab. If you have developed anything related to software, related to process, related to implant, that though research is considered as an invention, and you are converting that raw research into marketable product, it is considered as innovation. So there is a huge gap between invention and innovation in India, specifically. If you are talking related to academics, if you are talking related to individual persons, IP related issues. There is a difference here between invents and innovations. People are developing inventions. That means so many patent applications filed from universities, small scale industries, or large industries. They don't know how to convert that invention into innovation. That is the major gap or lagging issue that we are facing in the patent. So it need to be viewed with kind of need to be scrutinized and need to be viewed with the angle that how you can convert your invention into innovation. Innovation that is the product or the research you have done, it needs to be commercialized. That is the major aspect. At any point of time, you will going to feel that you have filed too many applications, we have not received any royalty or it's not commercialized. So why it is not possible? Because people don't move to converting invention into it. Increasing day by day. But then how to commercialize it? How to convert invention into it? That is the major in current. So today we will trying to touch that how IP, patent trademark copyright can be useful as an individual, how it will going to be useful as an individual, and how it will be used for academics, for institute. That we will try to touch in our today's session. So first we will looking into what are the IP, intellectual property rights. Now, related to intellectual property right, I will just brief you related to, we can say, 5 to 10 years down the line. People are thinking that IP is a kind of investment. Means they are having a kind of impression that it's better to invest in other instruments compared to IP. As we have in Gujarat, majorly we think that when I should invest in how I can able to get more returns in terms of R. Earlier, people used to have invest in land, going to purchase a property, going to invest in mutual fund, whatever. The different kind of instruments are there. We are considered as a conventional investment instrument, where you are going to have certain amount of ROI. Now, since last 5 years, or we can say recent last 3 to 4 years, in India, we are considering IP as an instrument investment. When you can invest, you can have a better rate compared to conventional, we can say, instruments that provide certain percentage of returns. So currently, thinking that this kind of IP will going to provide us good returns in terms of investment. So if you are, you might have heard of Shark Tank and everything. This is, we can say, in last 3 to 4 years, it's a kind of that every startup wants to get into Shark Tank on that kind of investment portal. So it's a tool. Why we present them as a technically advanced product or service provider or product? Because that kind of platform will provide you huge opportunity to get funding. In order to have any project, if you want to launch any product or if you want to launch any project, you first need a funders. So startup and everything, we can say that will only survive in case they will have funding at the right time. So if you are considering you as a dentist plus entrepreneur, in the future if you are considering that you are in not your training related to dentistry or you want to develop any institute where you can have a advanced research and development facility. So that kind of thing needs funding. So in order to attract good funding, you must have pattern for project or we can say work that can provide good return in future. Then the investor is going to invest in your project or field. So in order to have proper, we can say advanced project or any implant related we can say device, then you need pass through certain kind of a channel where it will consider as a this project or this method is passed through proper channel and this proper process can have opportunity to provide a good amount of return. Then and then people will going to invest in your project or product. Now, these are the I have tried to correlate with day-to-day, we can say, activities like what kind of IP you can think that in the future you can able to register. First is patent that protects novel technical inventions such as new dental instruments. That is a kind of a technical subject. Whatever you have think during your R&D research and development during academic, whatever you are thinking, it's related to product and process improvement. Then it will considered as a patent. That is the first IP. Detail, I will describe each and every subject matter. Usually, I will provide detail related to patent, but we will try to touch every IP in next slides. Related to trademark, you might aware about trademark because EMNR is the more common in generalized. Whenever you are going to market or in a restaurant or if you are going any event, then you will see the logo contains EMNR. So EM is a trademark and R is a register. So any clinics, I think from your perspective, I can give you example related to cloud dental and that kind of thing, that my dentist and everything. This and it contains a register trademark. They are wanting franchise model. We can say a new dentist or who establish clinic in any place. So that is a prime example of trademark. Related to design, take design application projects, aesthetics and visual appearance of dental products like braces, cosmetics, or packaging. So currently, packaging is one of the major thing that need to be concerned because in order to sell any product, either PC or either we can say practitioners, it requires some kind of good appearance. So it's not like that everything can be sold later in a raw. So right now, the packaging is also major part that you can consider as a design and related to copyright. Product copyright protects the original content related to dental. If you are running any channel where you are providing expertise to general public to YouTube or any of the streaming platform, you can go for copyright that specific. Now we will deal with in a patent. We will deal with an editing. I will try to provide you exact example where that specific company or entity has leveraged patent in order to get market share in India. So this is the actual case of OrthoFX. That is the they are we can say they are in alignments. So they trademark patented. They are using we can say patented only. They have specifically introduced paper or elastic and air shell lubricants. The aligners company, you are the subject expert. So aligners come with a different form. Might be polymer, might be a kind of metal composition. But both context provides specific optimized polymer composition. What they have done by protecting it to patent, they have received a product breakthrough with we can say that aligners designed for shorter year daily time. Means the alignment which is provided from perfects that need to be real for 9 to 12 years. If you are looking into the prior art or the subject which is the products which is available in the market, it requires 10 to 20 to 24 hours period. If you are orienting with a major breakthrough, what they have done, they have used polymer composition that requires shorter weird. So it is considered as a appealing in terms of dentistry or dentist or any end user. Now, you are selling with this kind of we can say one period. If you are using this product, you don't have to gear for a longer period of time. they develop one specific polymer feature that provides this advantage in terms of reducing weight. You know, we looking into weight. Out of all of that, currently Indian government or any startup are more focusing on patents. Why? Because it's a kind of tool that you can use in order to gain a market. If you are looking into the current topic, that's why I use this competitive dental practice. You know that what is the major problem in order to establish clinic or in order to practice. Competition is the major, we can say, hurdle that you need to think first that, and if you are going to establish clinic, then you need to think that at which area I should establish clinic, considering the competition. Because competition is the major problematic, we can say, I think that pro point in order to gain market share. So, how patent will going to provide, we can say, good result in terms of competition reduction? It's a kind of a tool that will going to provide exclusive right for 20 years. From date of filing of patent, you will have 20 years time. You can use this 20 years to exclusively use this product or anything. So this is the kind of time need to, we can say, it's a kind of sufficient time that you can use or commercialize your invention or product with by providing, we can say, license to others, by selling the product, by having a joint venture with other companies. If you are a dentist who is working in a small clinic and if you have developed anything, then you won't have to reach scale of the product. So that you can assign your greater license to company which is already available now. If your product is having that kind of strength, then your product can be assigned to some, we can say, companies who is already in market. Is, we can say, pioneering market, and you can have world from that thing. So it gives you exclusive right to make, use, sell for license. So that is the specific class that you can reduce the competition. Because without your, and yes, one more thing, it's an exclusive ownership. Means as a investor or as a patent holder, you can use your invention. If you don't want to use, that's fine. You can exclude others. Means you can stop others from using that product. It is the crux of patent. Because it provides you exclusive. Government will put certificate that is valid for certain time, or we can say 20 years. With that 20 years, if anybody is using, then you can legally file a suit against that infringer of the law. So that is the specific crux of patent. So it is, as I said, it is a part of capture market use. You can use it for 20 years without, we can say, hesitation, or the patent office or government is going to do it right for 20 years in order to secure that product. Now, if we are looking into both of them from the perspective, you are as a student or either as a practitioner, you are considering to file a patent, then what is this importance or what are the benefits? And if you are looking into the context of academia or institute, then what are the benefits of academia? That we related to practitioner means you are a student or in the future you are going to set up a field. Then what are the benefits that you can able to gain from patent? It safeguards new procedures or it will it's developed during practice during your videos or anything. Whatever you have developed, you can able to have an exclusive right. And in the future, you can able to license. As a practitioner, offer exclusive procedure or instrument that set your clinic apart. License the patented tool or method or to manufacture that generate passive income. and become recognized as an innovator in dental. Means if you have filed a patent or if you have received a patent, then you can say that you are innovator or you have done something differently from the we can say mainstream or the general practice. Related, if you are talking in another aspect, means related to academic institutes perspective, it provides it you can say it promotes innovation on faculty and students. There are huge competition in terms of academic. So many institutes are there that they want to have a students and it's a kind of let's say inflation in terms of seats of dental or pharmacy or anything. So if academic is a habit, so specifically for the parents, so I then they will have a leverage to use that innovator track, innovator institute in order to attract students. Patents showcase the tech potential and robotic industries partnership. If you have a good portfolio, then you can ask any multinational company or the Indian companies who are working in this industry to come in your institute and have kind of major industry kind of any in go for R&D. Generate income from licensing. I will cover this point in a later stage, that how Indian Institute will use patent as a we can say commercialized tool and a licensing tool to generate income, or we can say generate royalties. Strong IP code portfolio boosts academic reputation and NIRFs. So this is the major part. Currently, institutes are want to file multiple or portfolio patents just to get good recognition from NEC or NIR. So these are the points that institute as an institute they can consider why they should go for patent. Now I will try to cover three examples that in day-to-day routine, how you can think that any development related to we can say radiography or related to prosthetics or related to composition development, how you can able to think differently and look for innovation. So this is one example. The number is reflected in the US 7083779 B2 that is a registered patent. This patent is filed by CSIR, the Indian Research Organization filed the patent in US and received grant in US. This as a we can say a regular practitioner, you might think that you should do with herbal composition in order to solve any problem related to we can say pain killing or related to microbial, antimicrobial composition. By developing that kind of herbal products, let's say we can say cloud. If you can able to provide optimization of the ratio or selection of the ingredients in a precise manner or through we can say through testing data, if you are able to provide that kind of technical data, then you for better. It's not like that it's, each components prior art or in current industry and how I can able to secure my IP or patent. You just have to provide nationalization of selection of each ingredient or ratio in which percentage you are adding and how this addition of the percentage is going to provide technical advance over the product which is available in market state. Later, what we will consider as a innovation or innovative concept in terms of patent. So, by providing unique blend of verbs, stable formulation for model application, and if no prior disclosing same kind of combination with the specific composition, it's eligible for patent. If you are looking at the next example, this is related to we can say AI driven organization. This is also US patent that is one or I3 that specifically focused on how radiography or imaging will associated with the artificial intelligence AI, this will going to provide a unique diagnosis in terms of problem solving. So, if you think that by integrating your job with AI, and you will able to come up with any advanced analysis method, that is also considered as a way. Your software platform, if you're considering this specific example, if your software platform is a unique in terms of particular algorithm, then it is considered as an advanced. If you training, if you're looking into AI now, then you LLM, so large language model, if you're existing your LLM specific problem solving, in that case, it's considered as advanced or patent. Related to prosthetics, this is also one of the patent application in US. Patent application is 104634568. That specifically deals with the dentures. It's a kind of 3D that you might know that in order to have, we can say, multiple setting time or multiple, in order to reduce that hassle that patient need to visit multiple times in the clinic, they should develop the 3D printer. And by using the 3D printer, they can able to have dentures in it. We can say within the 30 minutes of property means they can develop dentures in a clinic. That is considered as advancement in terms of problem solving approach that patient needs do not need to visit multiple times in the clinic in order to get is supposed. So this is also a registered patent in US, 3D printed it's related to typing. It's not like that whatever you are filing will going to have a patent or that will going to receive a patent from patents. This invention or this project contains novelty, inventive step, and industry level. So, in order to relate other earlier three examples, if we are looking into this prosthetic printing machine, 3D printing machine, I have just tried to correlate what three criteria that need to be assured when you are dealing with a patent. So if you are taking your services, then it's a job of patent attorney to justify invention before patent office. Because patent office is not going to provide rights to any we can say innovator without scrutiny. Because it's a kind of exclusivity. If you are filing anything and the patent office will going to provide you certificate for we can say least technically advanced product, it means that least technically advanced product will have exclusivity for 20 years. So that is the kind of a thing that it should not be done in the context of patent because it's a kind of exclusive. As I have mentioned earlier, if you are a patent holder, then you have exclusive right to exclude others. If you are using or not, that is a subsecondary. You have exclusive right to exclude others. So with the patent office duty that whatever they are issuing as a patent need to be cross-checked with provisions of Indian Patent Act. For 20 years exclusively. So we will going to issue to IRR exclusively law. Is the patent patent was applicant, it's more responsibility to justify how this invention is novel in terms of patent provision, how this invention is technically advanced in terms of patent provision, and how this invention is industry applicable. So related to this prosthetics, if you can prove that this kind of a 3D printing is not available in market or it's a unique way of 3D print this prosthetics, then it's considered as an invention. Related to inventive step or non-obviousness, in non-obviousness, patent is going to provide 3 to 4 documents and patents which is filed in US or Europe or any advanced country. And they will say that this is not a technical advance in terms of specifically in terms of inventive step. So as a patent attorney, we have to justify that how this invention is technically advanced or inventive in terms of patent. By combining, if you are focusing related to this example on can nature production that discloses printing multi-structure with specific precision. If it is providing good result in a shorter time, then that is considered as an inventory. Related to industrial applicability, patent office might going to object industrial applicability in terms of mass scale production. So there is also a kind of objection that we need to be in invention file. In the next step, I will wait. What is the inventory step and industrial applicability criteria for this AI-based carriage detection? So patent office might issue some kind of a documents that disclose 30%, 40%, 50% in a different proportions disclose this kind of AI diagnostic method. We can say like this. Now you have to justify by combining all the and there is something which is technical elements that I have done in diagnosis. It's not like that we are just mentioning that AI-driven algorithm is unique or the method that we are capturing the angles in order to let's say it carries in the teeth that is unique. You have to show with the data that how this specific position of camera or specific position of the signal processing unit plays a vital role in order to achieve carriage detection in AI. Related prosecution means it's not like that. I mean, if there are all essential steps in order to file a patent, in order to prosecute patent, or in order to receive grant of patent before patent. So this is kind of stages. In our limit, we used to call prosecution. You will going to provide you ID or invention disclosure form. That IDF we will going to scan as a patent data like how this IDF can be converted into patent application, and how this patent application can be granted. So there are various stages related that we need to think. First is related to idea or invention. The idea is in day-to-day practice or in VGS report, in VGS study, you are with a specific idea. Then idea need to be considered as a topic. Right? How this idea need to be carried forward with patent filing. We need to decide with the ministry with the consultation of the patent attorney. Now, next stage is document. As a institute accepting to go into this application, then as a patent attorney, we will draft the whole application, prosecute that application before intended process. So they discuss it as a part of the documentation. As a document, or we can say as a patent, we have specific choices. You can go for a provisional file, provisional patent application, or complete specification. Provisional specification provides to, we can say, identity in terms of securing productivity. As I have mentioned that novelty is the crux of, we can say, criteria. So, as a institute or as a research fellow or as a technical person, you need to decide whether this invention is considered for a provisional filing or complete filing. If you have a detailed data, technical data, if you have data, then it is complete. After successfully defending it before patent office, the patent office will go to the certificate or we can say patent application will be granted. Once the patent office grant the certificate or provides exclusive right to the specific application, this will commercialize. The same certificate you can able to commercialize or as a person, it is a individual data so you can able to commercialize licensing of specific patent. If we are currently, as I have already briefed related to commercialization aspect, as a institute, these are some of the successful examples where institute has generated revenue out of it and gained so much, we can say, through licensing their patent to the industry, they have institute has gone, we can say, good royalty of providing licenses marketplaces. So IIT Madras and IIT Mumbai is the live example. They have used their IP of institute and they have gained a good amount of royalties. Yes. So regarding that, I think about the stats and this one. So stats are and then prepare a document and there any uh, manufacturer right? That's one. See, related to that, there is a difference related to provisional application and related to specification. Provisional application is about application. If you have a kind of a prototype, then you think that it will have a chance of getting patent or a chance of having a good commercialized product. You need to work in the probability that this prototype might successfully well in a period of time to develop. So if you have a demo invention, we can say related to that, 50% data is available that you work in detail. Then you show you can have a surety related to data. Then we can go for project. So provisional and complete depends on the stage of the project. If it's an advanced stage and you have already proper data, then you can go for complete. Yes, because once you have a product, then you have data. In terms of development of any, you can say, gel or if you develop any implant that is a unique in terms of ultimate object. So if you then you can test it. If you have a tested data, then you can go for complete full application. If we are having a certain we can say ambiguity that whether this product will satisfy our patent subject or how this will going to be in a kind of in a dynamic state. Then we will yes, so one more thing. Provisional sign will be advantage in terms of priority and in terms of communication. Because once you find provisional application, it will not publish. So your mobility is secure. Within 12 months, if you have not generated data, still the application is not public anyway. So after 12, you can further work over that project. You can have a data, then you can go for a content. So provisional application will not go. Yes. Once you because see, that is a kind of real world situation. See, as an institute, you cannot have much detailed technical, just education, much technical, much detailed and depth analysis. So you might be, we can say associated with any outer entity that is technical data. It's not like that we can look to generate technical data. But it may require that we need to have kind of third party testing whether this product is satisfied in ultimate object or not. So in order to make kind of institute or other entity, you need to have a testing. So as you find anything, you are not saving. You can share that confidential information to third party without getting. So there is that aspect provisional application. Once you have filed, you can say that it's a provisional application file. So they know that okay, it's a kind of a secret in terms of your name. See, the text of that was the issue. As an applicant, academic can also find individual organization. The major part in labor state that if you have done research and development by using resources of academic, then it's a kind of duty, you can say, ownership related issue. Then you need to file in the name of institute because you have developed in campus. It's not like that you have developed out of campus. So no, your idea or your process is same, but you have used the resources of institute. So if that And filing in flexibility will be considered as text processing is process is say any of institute need to file. So if you're looking into the principle of patenting, then it's a kind of technical quid pro quo, give and take phenomenon. As I have mentioned that it's a kind of government is going to provide or federal government is going to provide exclusivity for 20 years. So it's a kind of a time frame that they are providing you exclusive right in terms of disclosure that you have made. So after 20 years, the application will be in general domain or public domain. Everyone can able to use that application after 20 years or years after 20 years without any royalty or without any obligation. So it's a kind of a limited exclusivity monopoly right conferred by the state in consideration of the disclosure of invention. And now, see, these are the global patent filers for patent holders. Top 10 global patent holders. You might aware about the better you might aware about the names that global life and then Strawman and we can say Austin. They are the leading real innovators in the field. And I pointed that how many patents they have filed till now in their parent countries. The global lawyer that means at this time they have filed 136 patents in Europe. And if you are looking into the list of DO this films Korea, they have filed 30 applications related to their history. Now, this is the one of the key feature related to invention can be. Sometimes faculty students have a kind of let's say doubt that we are doing so many things at but we don't know what need to consider as an invention. It need to be considered as a precursor to file a patent. So in this, you can think related to fundamental research, improvement or existing product. There are two approaches. There are like four approaches. First approach is related to fundamental research. So what's the fundamental research? Does you what present an original concept technique of material not presented in the latest theory in then it is considered as fundamentals. If you look into the hypothetical example related to fundamental research, developing of that aspect-based biometrics for nature which is considered as fundamentals. So this is kind of a hypothetical example. You can consider as a precursor to movement. Next, improvement of existing product. Now, doing something on day-to-day life or in day-to-day practice, and if you are improving something, okay, help some kind of a potential in terms of commercial availability, then you can consider that as motivators. If you are looking hypothetical example, then modified suction heat designed for better fluid evacuation in posteriorly. This is kind of minor improvement that you are doing every time. But if you are going to the specific angle with suction heat guide, that angle provides a uniqueness in terms of shorter suction time or increases the patient compliance. In that case, it is considered as an improvement. You can consider that as improvement and you can consider again.
It's teacher of to modify. So may publish કરે છે તો બીજાને કઈ રીતે લાગે બીજા કોઈ બી આવે છે તો એ બંને ક્લેશ નથી કરતી બંને શેર છે કોઈ લિસ્ટ હશે
So you're perfectly identified the crux of patent planning. Every project need to be scanned with a prior access. Prior access is a word legal term. In language, it is considered as a literature thing. In thesis or in whenever you are presenting thesis, you need to provide literature thing. That anything you have done is a kind of you can say advance or we can say it's a kind of unique thing that you consider as a project or as a researcher. Considering already disclosed matters. So literature review kind of the thing that this is it's a kind of a section that you have refer this kind of technology and you come to the conclusion that I am doing this by considering this literature review and it is going to have kind of results. The same literature review, when any patent paper metadata is performing, it is considered as a prior art. Because in prior art, is a patent paper you can find opinion that this specific project have chances of acceptability from the patent. Okay, it's a chances of getting a grant from it. So this prior art search will going to justify or satisfy your questions or you we can say the purposes that whether I should go for the patent. So the parents which we can say if you are considering the importance of prior access, then it will provide two major benefits. First, it will one more we can say re-rating. If anyone has already filed a patent or if it is already secured a patent, then it's meaning for me. So it's will be considered as a reinventing the wheel. Now, second is a check patent. The three criteria that I have discussed, novelty, leadership, and industry applicability, these are the basic criteria because most is similar in all of the countries. Apart from that, Indian domain has some kind of unique patentability scheme. The thing which we have discussed in earlier slide related to detection of the carries from the radioactive, radio specific Indian patent mentions exclusive exclusivity and non-patented points related to diagnostic method. So, is a patent attorney here to take care your project or invention in terms of all basically domains of the patent. So, that kind of things will be checked as a patent attorney from prior art search perspective. We are going to find the perspective that all of the provisions related to patentability, non-patentability laws related to novelty, related to human tested, and related to disability, whether these inventions work like no, that depends on the data you can able to generate in the future related to provisions and related to complete planning. But we can able to provide some kind of assurity that there are chances that we can have a trial, but through this kind of data you can able to justify your invention in future. So this will going to satisfy the search analysis for the opinion from the metadata. Again, the data search will provide strength in terms of quality of data. Because when identifying if you as an inventor or as a patent attorney, if you know that these are the some kind of a disclosure which is already available in market or already published, then we will try to craft a claim that this that the boundaries of the disclosure will not going to circumvent your patent. So that will also going to satisfy drafting or claim strategy. About infringement risk. See, the thing which we have discussed earlier, we are thinking in a kind of optimized way that we are filing application and we receive grant and everything. So that is kind of a standard situation. Hypothetical situation for as a patent attorney or as a applicant. Sometimes what happens, the thing which you have filed might already patent there or might already receive patent from other multinational companies or the Indian companies. So by doing any if you are infringing their rights, means if anyone has filed an application related to that, and you are doing the same thing, and you are claiming that you are able to I am doing this thing in a legal way or in a legal intervention that might consider as infringement of the companies because they have already filed, and you are doing it in the same way. It's a minor way, but it will not going to deviate from the crux of that. So that is considered as an infringement. While filing regularly, you are stating that I am infringing the law. This is considered as a kind of thing where legal aspects will also. So by doing prior action, as an academy or as a veterinarian, we can have an idea that we are infringing or we are copying other aspect. So this is the crux of we can say triads. That need to be processed at a time finding patent application from anything you want to do it need to be processed. I think it's going to be example related to incremental innovation. The Nobel Biopic that we have for that they have had 1300 applications. It's not like that they are developing in let's say in a nutritional way or in marginal advancement is there. There is minor advantage, a minor advancement is there, but still they want to file application, still they want to secure the minor modifications related to technical. So this is a real about example of Nobel Biopic that we have discussed that is a major filer in what they have done earlier is a core invention. Means the core invention with the application number 57368 that was filed in 1995. Now, in core invention, they have secured impact having no coating, or we can say there is a no visual roughness in the invention. They have filed the core invention, the core patent in 1995. After having continuous research and development in 2021, again, they have filed modified version of it. They are focusing on specific quality and roughness. If you are looking into this advanced implant, then you can see that in a base part, they have ordered no roughness. That roughness will going to have foundation in we can say pretty. So that roughness for PIO coating is a kind of advancement that they are doing with earlier factors. That kind of advancement is considered as an incremental innovation that need to be protected. If local biochemicals don't protected this kind of roughness related advancement or PIO or related coating in a human daily life, then anything can be used without their permission, but because they don't find it. So, incremental innovation will be a game changer in nuclear option. So this is a real world example of a rural market. So as having curiosity that in inventions, they are finding as a we can say as a computer because 1500 applications in Europe is a kind of major number that what they are finding. So I was doing research and I'm going to this specific example that in 1985 they have filed a base application in 2022 they went to if not they have filed it in 2 millions. Now, related to patents, we can say related to AI, it's a kind of a territory plan. If you file application in India, you will have a right to explore eventually in India. So the example which we have discussed in earlier slide, Google Biocare or any hostel or New or you file application in the base. Means if you are related to bio or bio then that application in you for Switzerland. That parent country they are going to play right in India. So as a innovator or as a dentist, if you have developed anything, you can think in vice versa. If you find anything in India, you can claim the priority of your invention in forever. It's a kind of the same thing that the mobility, individual step, and industry applicability. They're the same criteria that will be following each and every patent. If you are going to US patent office or European patent office, you going to scan the invention in a, we can say 90 to 95% similarity is there in the application. So it's better think in a larger perspective, think global in order to secure good amount of royalty in terms of your your patent plan. Because they are the additional and they will need to provide good royalty in terms of your invention. So the key takeaway we can say is if you are individual for AI based on the invention, which is categorized as the basic improvement potential. Once you file application in India, you have a specific mechanism, you can claim the rights in foreign countries. So by doing that, you can explore the country in terms of commercial money. Because each and every patent office or government or any country will going to provide same kind of right related to making, related to selling, related to we can say licensing. But if it's an education, you can explore China, you can explore Europe, you can explore US. And as this data advanced country, they will going to acknowledge advancement done or technical development done in environment in a better way than India. Because they are developed countries and they are ready to do acknowledgement system or they are going to have good funding over the image. You can think that you how you can able to explore cross-border transaction from this foreign revenue. Okay, it's that the thing which we have discussed during prior answer. It's a kind of infringement analysis that need to be done in the project, whether the project or whether any development is infringing real-time technical law. That is the one of the crucial project, crucial task that by launching a new project, you need to go on a corporate search and by having a clear record, you can able to launch the product. It is one of the crucial thing for students in the academics. Each patent system follows the first two parts. Means if you have developed anything and you if you are thinking that still I need to do improvement, still I need to go for further research, and someone is going to find in their way. Someone else is going to find the same technology in their way, then you will going to lose your brand. Because each and every country follows the first two parts. You need to be first defined as a user. Otherwise, you will lose it. The same thing applies for communication. As a dentist or as a student, you think that we are good at that journal will academics value. So that's the in terms of patent filing. If you file anything in a journal without patenting, it is considered as a loss of knowledge. So it's always screen the project thesis or any product in terms of patent filing first, and then you should think about going into if you are publishing anything, then in a later stage you cannot feel that I have mistakenly or I am going to patent that and I have mistakenly published my research thesis that you don't avoid any you can say difference in patent. Now we will talk about design. This is also one of the important IP tool that you can able to use in terms of creative. So what is design? It's a kind of aesthetic opinion that how you relate to this brush. The overview has five multiple design applications with multiple variants of tools. Arrangement of bristles, then angle of bristles, and the holding pattern, the increment patient compliance. That things which don't have a technical application aesthetic or we can say user compliant or user convenience, then can be considered as design center. This is also one of these well designed registration for related methods. Related to trend, as we already discussed, now later, that is the building franchise model for establishing clinics. When trend, they are by leveraging their IPSX as a trend, they are providing franchise. So this is the one of the example of trademark revenue generators. Now, as a attorney, what are the expertise that we can able to bring into your IP? Because there are these are the projects. Identification of the process prior, the things which you are considering novel in technical advance might not be the work who takes some kind of technical plus legal side. The technical side need to be justified with the results of data. The legal side need to be justified with the interpretation of the claim or interpretation of the legal thing. So what kind of technological document as I tell you, able to write it, how we can able to community protect your invention as a whole. Determination of technical feature would be this a technical contribution. The case that we have discussed, providing roughness on the base of the design is considered as a technical contribution. Identification of the technical contribution, how we can convert the technical contribution into patent filing, that is the major limit that patent office, patent data will justify the patent application. Maintenance of deadline, yes. See, this is the crucial factor because once we file application, it's not like there is this is a black it will need to scrutinize to various stages of the examination report, yearly report, everything. After that, only they will be issue the patent if they satisfied the claim and your vendor category comply with Indian patent. So maintaining deadline is also one of the crucial factor. And follow up again, sometimes people, sometimes clients and the academicians want to cross check that why their office personally or what's the hotel. So as I tell you, so office. So real time data is equals to patent application. With that note, over with everything. If you have any questions, then we can discuss any questions.
So for Ryan, really,
Yes, because see, first we have to identify that whether we need to go to verify. So if you have a kind of urgency and if you break data outside institute, in that case we suggest you to go to provision because that will provide us a plan. And you can clearly have a kind of disclosure or and we can sign any insurance. Any company, such organization, uh, uh, in your readiness. But by the time you can set it 50% patent filing secure. Once it is filed, it is secure, related accident risk. And after filing, moving in,
okay, we can include this question. On behalf of NDC, I would like to thank spending some time and sharing the insights about what is patent, what is trademark, why is it important, if it created registry, what can be done, what should not be done, and many other things. Since this was like the first session, you understand for all of us, but since we get into this thing, and we all are into the business part, obviously we need to protect our business. As you clearly mentioned that for publication ensure product fit first. That is something the big takeaway for all of us. Right. So on behalf of ladies and gentlemen, thank you so much. Thank you. So I don't know how many understood the example. Let's start thinking like that's the one like what more thinking and to think something obvious than a thinking in the defense. And so said that invention and innovation are very different. When you start thinking in direct down in the what's happening with this thinking about, right? Can be your technique, the material, your instruments, wonderful, right? So, and of course, we will need your help.
Definitely. I think we have planned any project when networks in retail, that could be you can come from the office. You can do a Zoom meeting or online connecting means for any project that will be benefit.
Only at this one class. I at least we find a way to take up lot and we are still. Doesn't really something about it. We get to do all that. Right? So thank you so much.
Thank you. Thank you. Yes.